judiciary in making sure that this conference takes place and in doing everything they have done up to now to make sure that it is the success that we see at this stage. SG, where are you? Did she run away? Yeah. Well, she's standing there. There she is. Thank you very much. This conference is a response to many calls from various colleagues for a conference. You will recall that even in interviews in the JSC, there were calls that it is high time that we should have a conference. So this is your conference. Use it to ensure that our judiciary is a strong judiciary. Use it to ensure that decisions are taken that will make sure that the administration of justice in South Africa is put at a higher level. Nobody should feel small. All of us are judicial officers. All of us have a contribution to make. And I, speaking for myself, want to hear every view. I want to hear everyone. I want to hear whatever you think about the issues that we are discussing over the next 3 days. The theme of this conference is towards a single, effective, and fully independent judiciary. It takes place 12 years after the conference of July 2011, which happened during the term of office of Chief Justice Sandile Ngcobo, which was on access to justice and whose theme was, and I quote, towards delivering accessible and quality justice for all, close quotes. However, the difference between that conference and this conference is that the 2011 conference was not a conference of members of the judiciary only, but involved other stakeholders, including the executive. This conference is a conference of the judiciary. It is an opportunity for us to talk about issues that affect us. It is an opportunity for us to put our heads together to shape the future of our judiciary to the extent that we can. And as we shape that future, we must be alive to the fact that we will be contributing to the shaping of the future of this country. I've said that this conference takes place 12 years after the 2011 conference. However, more importantly, it takes place on the eve of this country reaching a very important milestone, namely 30 years since it achieved constitutional democracy. We are about 6 months away from that very important milestone for our country and our constitutional democracy. In a recent speech that I made at Gibbs a few months ago, I said, and I wish to say today as well, that the fact that next year our constitutional democracy will complete 30 years requires that all of us as a people should, ahead of that milestone, reflect on the journey that we have traveled, identify what we have done right in the 30 years that deserves to be taken into our 4th decade of democracy, and identify all that which was wrong that has been done in the past 30 years that should have no place in the 4th decade of our democracy. We must make sure that in the 4th decade of our democracy and beyond, we do not repeat the mistakes that we may have done in the past 30 years. And as a country, and not speaking about the judiciary, there are many mistakes that have been done. There are many mistakes that have pulled us as a country back. There are many mistakes that put us where we are. The least we can do is not repeat them. The least we can do is not take them with us into the 4th decade of our democracy. One cannot, in a speech such as this, deal with all issues that may need to be dealt with when one reflects on a period of 30 years. Therefore, one has to choose and identify those matters that appear to be quite important for the occasion and reflect on them. I propose to reflect on some of the features of our journey as the judiciary. In doing so, I do not propose to look at negative features only. I propose to look at positive features as well. But I also propose to look at some of the features that might not necessarily have been done by the judiciary, but that find space within the judiciary and which affect the judiciary. As I stand in front of you this morning, I'm very pleased at seeing the diversity that is reflected in all of you as this morning's audience. Because of that diversity, you are such a beautiful audience. Immediately before 1994, if a judges' conference was held, it would have been a complete opposite of what I see in this room. Because it would have been a conference of almost white men only. There would have been 2 white women. There would have been 2 black males. Other than that, it would have been white men only. The contrast between the diversity that is reflected in this room and the conference that would have been held immediately before 1994 reflects, in my view, the opposites that apartheid and democracy represent. With democracy, we see the inclusiveness that is reflected this morning. With apartheid, we saw the exclusiveness where the majority was excluded, where women were excluded. But when you look at this conference today, 30 years later, we see a lot of our sisters, we see a lot of black men, a lot of white men. It's beautiful. As was reflected in the Deputy Chief Justice's speech last night, great progress has been achieved in building a judiciary that broadly reflects the people of this country, both in terms of race and gender. We might not have reached our ultimate goal, but there is no doubt that a lot of progress has been made. This success on the transformation of the judiciary did not come on its own. It came as a result of hard work by various stakeholders, including heads of government, heads of court, especially the first group of black judges president, including the former judge president of Gauteng, who is here, Judge Bernard Ngwepe, who is here with us, and others. In fact, when I see him, and in the context of talking about transformation, I'm reminded of a part of his book, Rich Pickings Out of the Past, where he narrates the story that when he made himself available for, or when he was interviewed for the position of judge president by the Judicial Service Commission, where he was competing with two white candidates, one of the members of the JSC asked him or suggested to him that he should withdraw because age was on his side. He would be able to become judge president later. And that member of the JSC kind of suggested that he should wait, he should be patient. And Judge Ngwepe says in his book that his answer effectively was, I can't wait any longer. I've waited for 300 years. What needed to be done in order to reach the point that we have reached on transformation in terms of race and gender included that kind of determination. And indeed, Judge President Ngwepe, being judge president of the biggest division of the High Court in the country, went on after appointment to play a very critical role in transforming not only the Gauteng division of the High Court, but also as a member of the JSC for many years in the transformation of the judiciary in general. I was appointed to his division in 1999, and I remember very well at tea that if I didn't count acting judges, often there would be 2 black judges there out of about, I can't remember at that time whether 30 or 50 judges. But with his style of leadership, slowly but surely, he transformed that division. There are other judges, presidents, and other heads of court who did the same in other courts. Many of us called on government and the private sector to change briefing patterns in order to ensure that black practitioners and female practitioners got diverse work, diverse briefs, so that ultimately they would have exposure to different branches of law, and when they get appointed to the bench, that would enrich and transform the judiciary. Despite the progress that we made on transformation in the first 14 years of our democracy, the heads of court remained male only. However, in 2010, Judge Monica Liu was appointed as the first female judge president, and she joined the heads of court. At the moment, there are 3 female heads of court who are permanent members of the heads of court. Those are the president of the SCA, judge president of the KZN division of the High Court, and judge president of the Mpumalanga division of the High Court. If we include acting judges president, that number is doubled to 6, because then we add the acting judge president of Limpopo, the acting judge president of the Western Cape, and the acting judge president of Limpopo, the acting judge president of the Western Cape, and the acting judge president of the Land Claims Court. Apart from transformation, we have, over the past 30 years, ensured that certain institutions are established which are important to the judiciary. I remember many years ago when I was still judge president of the Labour Appeal Court and Labour Court, when Justice Arthur Chaskason was the Chief Justice, and we began to talk about the need for the establishment of an institute for training judges that would be controlled by judges. There was at the time a lot of resistance to the idea that judges needed training, but over time, attitudes began to change, and it was resolved that an institution be established that would provide training to judges. And hence we have the South African Judicial Education Institute, which provides such training to members of the judiciary, which is a director or CEO, and that institute in the 2022-2023 financial year provided training to 3,799 delegates. SAJE gives us the opportunity to provide training to the judiciary, offered by the judiciary and controlled by the judiciary. This is very important because it enables us to ensure that we do not send judges to receive training in institutions which are not controlled by us as the judiciary, and where we are not in control of what kind of training is given to them, and we might not know where the funding comes from, which makes that training possible, and what agendas those who provide funding might have. Of course, there may be lots of places which provide training which is genuine and legitimate. But where we provide the training, we determine what is taught in the institution, we stand a better chance of avoiding a situation where there might be allegations that the judiciary is captured because of whom may be behind the training that they get. We have already been accused of being captured, but it is an accusation that we reject with the contempt it deserves. Because for 4 years, I called for everybody who had evidence that the judiciary in South Africa is captured, and nobody came with any evidence. Up to now, nobody has come with any evidence. The accusation is made by those who wish to ensure that the judiciary of South Africa is not trusted by the public, that it is looked at with suspicion because it suits their purposes, that the judiciary should be viewed with suspicion. No evidence has been put forward to support any such accusation. Under our constitutional democracy, the independence of the judiciary is provided for in our constitution. The individual independence of the judiciary may be easily abused by some unless there are clear systems and mechanisms in place to ensure judicial accountability. For many years, there were no clear systems and mechanisms to hold judges accountable for unacceptable conduct and for conduct such as undue delays in handing down judgments. It took more than 15 years after the advent of our constitutional democracy that amendments were made to the Judicial Service Commission Act to establish the Judicial Conduct Committee, which processes and adjudicates complaints against judges, which are viewed as minor or serious but not impeachable. Where the JCC takes the view that a complaint is likely to lead to impeachment if established, it recommends to the JSC to ask the Chief Justice to appoint a Judicial Conduct Tribunal to investigate and report on such complaints. This is one of the institutions that we have created over the past 30 years in order to make sure that members of the public who have got complaints against judges have got a place where to go and lay those complaints. Under apartheid, there was no such body. Indeed, I want to take this opportunity to thank all judges who give up their time to serve on the Judicial Conduct Committee in order to make sure that this body operates. And I want to take this opportunity to also thank heads of court, because they too play a very important role in the processing of a certain category of complaints that are referred to this body. The Office of the Chief Justice is one very important institution that was created during the 30 years of our democracy. It was created by a proclamation 44 of 2010, on 23 August 2010, which amended Schedule 1 to the Public Service Act of 2010 to make provision for a new department. It was established by President Zuma. This was a very important step on our journey to a complete institutional independence as the judiciary. And we must take this opportunity to express our appreciation that President Zuma, during his term, established this institution. It now remains for those who came after him to take this project for the institutional independence of the judiciary further. I say those who have come after him have the responsibility to take it further, because for about 10 years after it has been established and after the judiciary had handed over to the executive a report that had been produced by two former Chief Justices of this country, Chief Justice Langer and Chief Justice Chaskalson, which made recommendations on what steps needed to be taken in order to ensure that we in South Africa have a judicially based court administration. For over 10 years, the executive did not respond to the judiciary. And in that way, our fight for a full institutional independence was impeded. It is a pity that on the one hand, President Zuma took such an important step of establishing this very important institution, but for many years thereafter, the executive did not take the matter further. I'm glad, however, to say that last year, towards the end of the year, the executive came back and they said they had been researching so that they could give us a response, and they gave us a response. Because the committee of the two Chief Justices had indicated in their report that there were some matters that still needed to be investigated in regard to the model that they had recommended, I appointed a committee chaired by Judge Ngwepe to look into those issues so that we can have finality. And that committee is soon going to give me a report. But I'm happy to say that the executive has already indicated that they would like us to meet to have a preliminary discussion about the kind of court administration model that South Africa should have. We have our own, they have their own. There is a need for discussion. That meeting was supposed to have taken place on the 29th of November, but it was postponed. I have no doubt that it will soon be rescheduled so that those discussions can take place. It is my wish that next year should end with a final decision so that soon South Africa will have a court or judicially based model of court administration. When we talk about some of the features of our journey in the past 30 years, we must be free to talk also about the fact that among our courts, there have been challenges, but we have learned certain lessons from those challenges. Here I talk about the fact that the creation of certain courts after 1994 created certain uncertainty about the jurisdictions of some of the courts that had been there before. In this regard, we know that under the Constitution, the interim Constitution, and the final Constitution up to the 17th Constitution Amendment, the Supreme Court of Appeal and the Constitutional Court were at the same level. The Constitutional Court was the highest court on constitutional matters, and the Supreme Court of Appeal was the highest court in other matters. And this did create some tension. And those who have been around for some time will recall that there emerged at a certain stage certain judgments from both courts which indicated that there were certain tensions because the one court was the highest court in a certain area and the other one was the highest court in other areas. One known case is the logistics, where the Supreme Court of Appeal sought to say common law review is not constitutional, and the Constitutional Court in pharmaceutical subsequently said common law review is also constitutional. There are no two systems of law. We know also there were certain tensions between the Labor Appeal Court and the Supreme Court of Appeal, as well as the Competition Appeal Court and the Supreme Court of Appeal. But out of all those, as the judiciary, we emerged better members of the judiciary, and the courts emerged better courts. Of course, ultimately, the appellate jurisdiction of the Supreme Court of Appeal was taken away in regard to labor matters and competition matters. But there's no doubt that now there is no tension whatsoever, because through those lessons, we became a better judiciary and were able to handle and are able to handle whatever challenges there may be. One of the areas where the judiciary of South Africa has performed exceedingly well is in performing its function of protecting the Constitution, of protecting the rule of law, of protecting the independence of the judiciary. One need not substantiate that, because it is there. We all know it. Indeed, the judiciary of South Africa is respected internationally, in part because of its record in upholding the Constitution, in upholding the rule of law. The judiciary of South Africa has done that despite the fact that, to a very large extent, many of them work under extremely difficult conditions. The conditions under which the lower judiciary operates are worse than those of judges. And yet we know that for most people, when they talk about justice, they talk about what they see in the lower judiciary, which means it's very important that there are conditions of service and the courts where they operate should be in acceptable conditions. In some of the courts, in the lower courts, Judicial officers have to park in the streets, and when they go in the afternoon, they find a witness or accused parking behind them. In some of the courts, in the lower courts, judicial officers, when they come out of court, are forced to go through the public to get to their offices. Many courtrooms in the lower courts, many courts have got not enough courtrooms. Almost every fourth magistrate's court complains that they need more courtrooms. A number of them operate from old buildings that are dilapidated. Load shedding disrupts the operations not only of their courts but the superior courts, except where there are generators, and generators are not in every court. And when there is a backlog of cases, such as we sometimes see in the annual judiciary report, the public needs to know that part of the problem is load shedding. But part of the problem also is that there are vacancies that are not filled of judicial officers, and also in some courts, such as the labor court, new posts need to be created so that judges can be appointed. And yet, the government takes ages to address that problem. It is a problem that has been there for a long time in the labor court. Cases are taking long to be set down because there are no courtrooms. But there are many other courts which have similar complaints. And indeed, we must fight for a full institutional independence of the judiciary, where we can control the funds, the budget that we need in order to make sure that court operations are able to run smoothly. I will not talk much about institutional independence, court administration, because there are speakers who are going to talk about that. But there's no doubt in my mind that we need institutional independence in order for us to be able to turn things around in many of the courts. Some of the stories that one hears are stories where a judicial officer sits next to a witness to hear their case because the space is simply not enough. If we handle some of these things ourselves, certainly the situation would not be like this. Before I conclude, I want to go back to a point or to an issue that I believe is very important. It is the personal independence of judges. It is an issue I like talking about because for me it is so critical for our judiciary. Because You may have full institutional independence. If you don't have personal independence, an environment that enables judges and judicial officers to make decisions that they are called upon to make without fear or favor or prejudice, you will not have a credible judiciary. Our judiciary has been tested, and each time it has come out strong. Of course, the greatest test that it was put to was in 2021, when threats were made in the media by people who did not want the Constitutional Court to make the decision that they believed was correct when a former president defied the Constitutional Court. That, for me, will remain one of the most important moments in the history of our judiciary, when our highest court was defied and threats were made against the justices of the highest court in order to try and pressurize them to make a decision that they might not have wanted to make. But they stood their ground. And there are high courts which have done the same in various matters. And that is very important. The integrity of all judicial officers, their commitment to their oath of office, and their commitment that no matter what, they'll make their decisions without fear, favor, or prejudice, is central to our judiciary and is central to our democracy. I wish that we should do more as we recruit new judges to make sure that all those that enter the judiciary have got what it takes to make sure that no matter what the circumstances are that they will come across, they will always be truthful to their oath of office. That is one of the things that we must take with us into the fourth decade of our democracy. With these words, I declare this conference duly opened. Thank you very much.
Thank you very much, Chief Justice and colleagues. In the process of introducing the Chief Justice, DCJ Maya said, we must use this conference to rigorously examine the state of the judiciary. That's our DCJ, true to form. When I called her to the podium, I referred to her as the matriarch of the judiciary family. I used that word advisedly. The DCJ has been the senior female member, the most senior female member of the judiciary for a very long time. She has a proven track record. In 2015, she was appointed as the very first female Deputy President of the Supreme Court of Appeal, followed by an appointment as the first female president of that court in 2017, and followed by an appointment as the very first female Deputy Chief Justice of South Africa. So in that sense, Deputy Chief Justice, you are the matriarch. In isiXhosa, you are a true mafungwash. Yes. And I must tell you that we have very high hopes for you for the future, my sister. And Chief Justice, thank you so much for your heartwarming, all-encompassing keynote address, which highlighted the challenges faced by the judiciary, but also proposed actionable solutions. I will not attempt to summarize what you said. We all heard you, Chief Justice. I will not try to summarize what you said, lest I water it down. Thank you for your words of encouragement, and in particular, thank you for extending an invitation to all delegates to participate actively in this conference. You said, Chief Justice, you want to hear every view, and you want to hear everyone. That's our Chief Justice, true to form. Chief Justice, you also said the conference is an opportunity for judicial officers to talk freely about things that concern them, and most importantly, to put our heads